A controversial ruling today by the Supreme Court.
The court struck down a crucial part of the Voting Rights Act of 1965. News 13's Evan Donovan joins us with more on the reaction to this ruling.
Evan, what does this mean for voting laws in North and South Carolina?
Well, it means election officials in either of the Carolinas won't have to get permission from the federal government to change voting laws, ending a 50-year protection dating back to the end of Jim Crow laws. In a landmark ruling today, the Supreme Court declared unconstitutional Section 4 of the Voting Rights Act of 1965, which forced 9 states, including South Carolina and 40% of North Carolina, to get permission from the federal government before changing any of its election laws, even something as simple as a polling location.
In other words, before the politicians in Columbia, Raleigh could change or locally, could change our right to participate in the political process, it had to go through a review by people who weren't politicians.
That pre-clearance process is now no longer necessary, but the Voting Rights Act is still in place, and the ruling leaves open the door for Congress to recalculate which states fit under the formula.
What this does is it says states are innocent until proven guilty, not guilty until proven innocent. And if Congress wants to go back and adjust that formula to 2008, 2012 election criteria, they're welcome to do that. But don't judge us on a 50-year-old formula.
Measures like the voter ID law passed in South Carolina last year and proposed in North Carolina would now be able to become law without federal approval.
Had this court ruled at this time last year, South Carolina would not have had to go ask the Justice Department for permission. We simply would have had the law go into effect, and that would have been a huge savings to the taxpayer.
The decision was split 5-4 along the court's ideological divide, with Justice Kennedy joining the majority opinion. Both sides agree that it does underline the success to date of the Voting Rights Act.
The only way it could reach the conclusion it reached and overrule Congress's conclusion is by saying, well, so many good things have happened in large part as a result of the Voting Rights Act.
Now, the ruling does allow Congress to come up with a different formula to apply to Section 5 of the Voting Rights Act, but many critics say that's a tall task in this divided Congress.